Courtroom 2, we are ready to begin whenever you're ready. Deputy Francois, good morning. Oh,
Good morning. We're trying to assist ACDC for the Zoom link, Judge. Good morning.
Whoops, I can't make out what you're saying. What did you say?
Judge Law, can you hear me?
Now I can, yes.
Okay, no, we were assisting ACDC with the Zoom link so that they can sign on.
Okay, and Mr. McLean, do you have the announcements for the PDs? Has that been sent in?
Yes, Your Honor, they were sent in. We have all the announcements.
Okay,
Um,
I'm troubleshooting.
Casey Strong should have those able to forward to you in written form.
okay. Just as soon as we get started, we can get going.
Judge, I'll send you the announcements.
Thank you, appreciate it.
Okay. Are we ready to be able to start for the probation calendar?
Yes. Mhm.
Mr. Martinez? Slayton?
I don't know what's up.
This is gonna be on the probation calendar, Judge Law?
Okay,
13.
Francois, is there someone talking on the side? It's very loud.
Yeah, Norris, can you pick up the? Yeah. I wiped it down.
Okay, thank you so much. All right. And in probation, we have position number, was that Norris? No,
This is positions 13 and 14, Mr.
13, 14, okay.
Some of them.
All right. Good morning, ladies and gentlemen. My name is Judge Lal, and this is the combination calendar of state all-purpose as well as the probation revocation, and we also may handle some bench warrants today. These calendars are with the State Court of Fulton County, and they include all cases in which misdemeanor offenses are involved. If you're a defendant charged with one or more misdemeanor offense, or if you're here on a probation revocation calendar, please remember that you have a right to remain silent. Anything you choose to discuss about the facts of your case during the course of this virtual proceeding, your statements can and will be used against you. So if you have anything to inquire or ask, I would recommend you first speak with your attorney. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you from either the Public Defender's Office or from our conflict defense list. We are addressing a probation revocation matter at the present time, and this is State versus Augusta Martinez. Mr. Martinez, you have an underlying case on position and I don't know why here it is on position 13. Position 12, and that is 23 PV 001631. That's your probation violation case. And position 11 is 22 CR 5970H. Mr. Augusto this was a conviction involving a offense that I'm going to waive sounding. So, Officer Brooks, are you the probation officer in this matter?
Yes, Your Honor, I'll be sitting in today for court.
All right. Let me go ahead and place you under oath for all the probation revocation cases. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. We're going to waive sounding on Mr. Martinez's conviction. If you can tell me the reason why the state is seeking a revocation.
Yes, Your Honor. And just to double check, this is for Mr. Martinez, correct?
Yes, Augusto Martinez. The underlying case is 22 CR 5970H.
Thank you, Your Honor. We're seeking a revocation due to the fact that he was court ordered to complete a sexual offender program. And this is not his first hearing. He was brought back initially on July the 18th. And at the time, the judge ordered him to begin the classes by the 25th. On the 25th, he went back and he did not, and therefore 20 days was revoked. And he was requested by the judge at that time to return on August once he got released on August the 13th, to come back for another hearing on August the 17th. And he failed to appear for that hearing on August the 17th, and a warrant was requested.
What's the state's recommendation for revocation?
Revoke.
And how many more days does he left?
He just has 11 days remaining.
All right, thank you. Mr. McLean?
The recommendation of the probation department is to.
To revoke the balance. He's got 11 days left.
Okay, if I might go mute for just a moment, Your Honor, I was thinking this was on another line. Hold on for just a second.
And Officer Brooks, can I confirm he had 14 days left on his probation, 1-4?
Your Honor, it's 11 days. He
It's
has
11 days, excuse me.
11 days.
Yeah.
No,
Mr. McLean, he's been in custody for 14 days. He'll be commuted to time served.
Okay.
Where is he going?
Your Honor.
Where is he going?
Your Honor, this is not Mr. Slayton. We're getting Martinez to the desk.
Oh,
So
Augusto Martinez.
there was a little mix up there for a sec. So I'm going to talk to him for a moment. Yeah.
Boy, he must have been befuddled. Okay.
We all were.
All right, that's all right. So, Mr. Augusto Martinez, is that your name? Good heavens. All right. Mr. Augusto Martinez, your case number is 22 CR 5970H, in which you were convicted of an offense. The probation case number is 23 PV 1631. And it appears that you failed to complete the program that you were required to do. You failed to comply with the prior probation revocation hearing. You failed to return on August 13th, 2023 for your last known revocation hearing. And currently you have 11 days left in your probation. The state is recommending that we revoke your probation this time. Would that be correct, Officer Brooks?
Yes, that will be correct.
And Mr. McLean, your client has 14 days already in jail. I can commute this to time served, and that will close the case out.
We would ask the court to commute his time served, Your Honor. That would be appreciated.
This will be marked as a probation violation, is commuted to time served. If he has no other holds, he should be released within 24 hours. Thank you. Next case, please.
This is on a probation calendar, positions 13 and 14, Slayton.
Oh, okay. Your Honor,
Yes, sir.
I'm going to get back to the court on Mr. Martinez. I've got to get a Spanish interpreter to make sure he understands everything that was just said. Thank you.
We don't
I'm
speak.
good. Okay. Let's put the case on the side and let's go to the next case.
Right.
All right.
So we didn't know that.
No. All right.
Slayton, probation calendar, positions 13 and 14.
All right. Is this Antoine Xavier Slanton? Need to say yes or no.
Yes.
Okay. Mr. Slanton, your underlying case is 23 CR 4684C, in which you were convicted of battery. Your probation violation case is 23 PV 1632. You have been advised of your right to remain silent, and your attorney is Mr. McLean. Officer Brooks, you're still under oath. What's the reason for his revocation?
We're here, Your Honor, because he was court ordered to complete 8 weeks of anger management and placed on probation for 12 months. He has never reported to probation.
And how much time does he have left? 12 months?
He has 227 days remaining. He was placed on probation on August 10th, 2023.
And he has never reported?
He has never reported, and we reached out to him several times.
All right. Do you know if he was held anywhere, any other jurisdiction?
Not that I'm aware of, Your Honor.
Right, is the state recommending that he complete the remainder of the 227 days in jail?
No, Your Honor, we're recommending that he continues on probation and is required to enroll for his program within 30 days.
All right, thank you.
Mhm.
Mr. McLean, any objection with that recommendation?
I can't imagine, I'll double check. Is there any objection that you would have to continuing on probation?
No,
And
I'm gonna do what they say.
you're gonna do what they say?
Yeah.
He sounds enthused.
Well, I was going to recommend that he spend the rest of the 227 days, just to get it over and done with.
Your Honor, I promise to do what I have to do and do my
I
program.
need a reason why you haven't been doing what you need supposed to do since August.
Ma'am, I'm currently homeless. I didn't have anywhere to stay. And I tried to get in contact with the court several times and I didn't have any way of getting in contact with anybody.
But if I keep you in jail, you will have somewhere to stay for the next 227 days.
Yeah, but I want to do I promise to do my program and do what you guys tell me to do and get the probation over with. You're on it's all with my life.
You did not even report once. I'm still not convinced.
No, Your Honor, I called my mom and I tried to get
Your mom is not your probation officer, even though my kids like to think so.
Yes, ma'am. But I promise to do what you guys tell me to do and I will
If I
never.
see you again, I will definitely revoke your probation.
Okay, thank you so much, Your Honor. I promise you'll never have this problem again.
I think what you were saying that you promised never to see me again. All
Yes,
right.
yes.
I'm going to accept the state's recommendation. He will continue on probation. He will report to probation on Thursday, which takes about 24 hours for you to be released from jail. Today is Tuesday. You report on Tuesday before 3 p.m. and that's at 132 Mitchell Street. If you fail to report, another probation warrant will be issued, and then, well, you know what I'm going to do next time.
Yes, ma'am.
You will continue on probation within 30 days from today. You are to enroll in a anger management program, and every time you report, you are to show that you are attending those classes. You have 8 classes to complete. You will report to probation every month until the 227 days are completed.
Okay.
That concludes this case.
Okay, thank you so much, Your Honor.
Your Honor,
Yes,
I'm sorry, excuse me. I just need clarification. You requested he report was that Tuesday or Thursday?
Thursday, this Thursday. Today's Tuesday,
Okay.
right? I got to keep that in mind because I normally do the Thursday calendar.
Yes, okay, thank you.
Okay, thanks.
This is position 16 on the regular calendar, Mr. Green.
Oh, yes. Your Honor, may I mute for a second? There was, had made the announcement, there was one additional piece of information from the Solicitor General's office.
Go ahead. Yeah,
This is them. Thank you.
and. Okay.
And Your Honor, just to make an announcement, if this is Bayern Green, position 16,
Yes.
the
that was
DA's office. Oh,
Go ahead. I'm so
excuse me.
sorry. I read your email, but refresh my memory.
The DA's office did accept this for transfer. I'm just waiting for them to sign the order and submit it so that we can have the case assigned a CP number.
Okay. I think Mr. McLean was hopefully listening to that. And thank you, Mr. Jordan. I received the announcement list. I've just got to print it out. All right, Mr. McLean, just to go with the prelim on Mr. Green, is this Bayern Green?
Yes, it is, Your Honor.
All right. His case is 23 CR 357F, in which he's accused of battery, family violence, and cruelty in the 3rd degree from September 16, 2021. The prosecutor, Mr. Green, has been advised of his right to remain silent, and his attorney is Mr. McLean. Mr. Green, the prosecutor, Shelley Falk, has just announced that your case has been accepted by the district attorney's office to be treated as a felony matter. So your case will be transferred to the Superior Court of Fulton County. Mr. McLean, anything else to address?
Your Honor, I will have someone from the felony division of our public defender office contact him here.
All right. Okay, that Ms. Falk, you can submit it to Ms. Strong for signature. And Mr. Green, you will be contacted by the Public Defender's Office that addresses felony matters. Thank you.
All will be explained by the other one.
Positions 24 and 25, Mr. Means.
This is a negotiated plea, Your Honor.
Okay. All right. I'm sorry, I'm just trying to get the email with regards to the public defender's announcements. Was that the last email you sent me, Mr. Jordan?
I sent you two, Judge. One was from the public defender and one was from ASC Falk.
I,
So the second one I sent you was the solicitor announcement. Or please.
oh no, I was looking for the public defense announcement. I've got the solicitor announcements.
So I sent you that one too. I'll try sending it again.
Oh, just the PD announcements, please. Thank you. All right, sorry about that. That was a position, Mr. McLean, who's your client right now?
Ricky Mean, Your Honor, MEAN.
Okay,
It
got it.
turns out he's saying there isn't, there's supposed to be an S at the end of it.
Okay,
I'll put it correctly on the thing.
all right. So this is position 24 and 25 on the SAP calendar. Ricky Means, case numbers are 23 CR 5352J, in which he's accused of criminal trespass. And he's got a bench warrant matter 23 FTA 1105. Mr. Means, you've been advised of your right to remain silent, and your attorney is Mr. McLean. What's the announcement in this case, Mr. McLean?
A negotiated plea, Your Honor.
All right. And Mr. Means, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
I can't hear you.
Yes.
Thank you. All right. And Ms. Falk, what's the recommendation for Mr. Means?
Yes, Your Honor, the state's recommendation is 12 months probation, serve 32 days, credit for time served 16 days. That's from September 4th, 2023 to September 5th, 2023, and then November 29th, 2023 until today. Ballots probated, no contact with Jean Njombe, that is NDJOMBE. Stay away from 266 Garnett Street, and we are asking that restitution remain open for 30 days. We did have an opportunity to speak with Mr. Njombe, and he does agree with the plea. He, however, stated he had not had enough time to get an estimate on his windshield, and it was not covered by insurance. And so that is why we're asking that that restitution remain open to give him an opportunity to turn that over to us. The state would ask the defense stipulate to venue, factual basis, and identification, and we would like to sound for Mr. Njombe.
We do so stipulate, yes.
Mr. Njombe? All right. And Mr. Means, did you consume any medicine or alcohol?
Listen to the court.
All right. Are you done writing?
He is, Your Honor.
Okay. Have you consumed any medicine or alcohol?
No.
And have you understood the proceedings?
Yes, ma'am.
Are you satisfied with your attorney?
Yes.
And is anyone forcing you to plead guilty today?
No.
If you decide to plead guilty today, you would have to come back to court to have a hearing on how much you owe the victim. Are you prepared to do that?
Come back to find out how much I owe? Yes, how many dollars you would owe for the windshield. How would I find it out?
The allegation is that you damaged a victim's windshield. So you will have to come back to court and have a hearing on how much you owe the victim for the damaged windshield. Are you prepared to do that?
So you have to give us a way of getting in touch with you so we can inform you of coming back to court.
Could I just be on probation until,
Well, and probation will also have your phone number and your address.
could I just report to probation until?
You will be reporting on probation, and then at some point in the next several days, we'll find out what the hearing date is.
Okay, can I do that?
Yes, that's what she's saying.
Yes, I know.
Yes, that is exactly what the court's saying.
Yes, sir. Yes, sir.
You have to report to probation and you have to come back to court to have the hearing on your damages, on the damages.
Yes, sir.
All right. If you decide to plead guilty, you would also have to give up your rights to go back to court and have a trial. You will not have a trial. You will not have a chance to confront your accuser. You will not have a chance to challenge the evidence brought against you and present any defenses or mitigating factors if you choose to do so. And you will have to give up your right to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Now, so the, legal being in court, so I have to, this court case will be over with, or I have to come back?
No, court is not over and done with. You still have to come back for a hearing on damages. But
Okay.
if you want to plead guilty, you will not have a trial. Are you prepared to give up all your rights associated with the trial?
No, ma'am.
Okay, then we are going to have a trial. Mr. McLean, your client has not willing to give up his constitutional rights.
I think he probably should listen to the.
No, I ain't
questions a
listening,
little-
I'm talking
listen to the
about.
questions a little better and considerably better and listen very carefully to what the judge is asking you and give your answer.
All right, I'm going to ask again. Mr. Means, we've already figured out that you will come back to court to have a hearing on the damages, correct?
Yes, ma'am, I'm coming.
Okay, now this is a different subject. Pay attention. If you decide to plead guilty, you would have to give up your right to a trial. That means you will not have a chance to go back to court and have a trial in front of a judge or jury with regards to the charge of criminal trespass. You will not be able to confront your accuser. You will not be able to challenge the evidence brought against you. And you will have to give up your right to have the state, the prosecutor, try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Repeat. What's your response? I can't hear you.
Yeah, I'm ready to give it up.
How do you plead to one count of criminal trespass? Your sentence is 12 months to be served on probation. You'll report to probation next Tuesday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. If you miss your probation date, you will be back in jail. While you're on probation, you'll be, your sentence is to serve 32 days, credit for time served 16 days. The rest of the time will be on probation. While you're on probation, you are to stay 200 yards away from Jean Njombe, and you cannot return to 266 Garnett Street in Atlanta, Georgia. You're to stay 200 yards away from that location. While you're reporting to probation, please keep asking them when is your restitution hearing, because you will have to come back to court to hear how much you owe the victim for the damaged windshield. And you will have to pay that amount to your probation officer so that the victim can be made whole. Thank you.
Your Honor, Mr. Njombe is here in court. He just came a little late, but he would like to speak.
Which one is he?
I believe it's iPhone Detiti.
All right, Mr. Njombe, if you could please unmute. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. Is your windshield still damaged?
My windshield get repaired by my insurance, but beside the windshield, it also apparently
Mr. Njombe, is your windshield still damaged?
it's repaired.
It's repaired. How much did it cost you to repair the windshield?
It didn't cost me money because I had it on my car was on full coverage.
Okay, so it didn't cost you anything. What else was damaged?
The windshield, pad control was damaged.
I don't understand your response.
Your Honor, I said the windshield control inside the car next to where I turned on the car was also broken.
Do you have an invoice from a mechanic?
Not yet. I was thinking to do that this morning, today when I leave from work.
You have
I
48
don't-
hours to present your invoice to Ms. Falk, the prosecutor.
I don't understand what that part is. So
Me neither. But you have 48 hours to present your invoice to Ms. Falk. And Ms. Falk, if this was an item of damages that was disclosed to the prosecutor before today, then it is recoverable at a restitution matter. Otherwise, the restitution matter is closed out.
Yes, Your Honor.
All right. Mr. Najombe, please contact the prosecutor with regards to your invoices.
Okay, Your
Thank
Honor. Thank you, Your Honor.
Mhm. All right, next case, please.
Position 28, Tidwell.
This is Travis Tidwell, position 28, case number 23 CR 77678. Are you Mr. Tidwell?
Yes, ma'am.
Thank you. Mr. Tidwell, you were cited for accused of driving under the influence of alcohol and driving while license suspended or revoked on November 28th, 2023. You've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, how are we proceeding?
This, Your Honor, is a non-negotiated plea.
All right. Mr. Tidwell, the prosecutor is going to give me a recommendation if you decide to plead guilty to these charges, and your attorney is going to give me an alternative recommendation. I will let you know which option I'm going to select, keeping in mind that I also have the right to disregard either and set the case down for trial. Ms. Falk?
Yes, Your Honor. This incident happened at 928 Canton Street on September 28th, 2023. Officers were dispatched in reference to a domestic dispute between a husband and wife. They saw the vehicle, which the defendant was inside. He displayed bloodshot, watery eyes, the odor of alcoholic beverage on his breath, and the defendant was unsteady on his feet. He did admit to drinking and operating the vehicle from the nearby hotel to that location at 928 Canton Street. Defendant was also found to have a suspended license. The defendant's previous history is what led us to make the recommendation that we made on this case. The defendant has a 2011 conviction for driving while license revoked, where he received 12 months, 2 days to serve, and a $615 fine. In 2012, he had a driving without a license where he pled NOLO, received 2 days, 12 months probation, a $500 fine. And then in 2016, he had a DUI alcohol where he received 12 months, served 1 day, a $500 fine, risk reduction, victim impact panel, and 60 hours of community service. Additionally, and let me just pull that up really quickly. I believe.
Are there any probation violations in his history?
There are no probation violations in his history, Your Honor. Our main concern was the previous offenses for the exact same thing he was charged with in our case, which was suspended license or no license and DUI. Additionally, and I just want to check his criminal history because I believe he also has a pending case, but I just wanted to make sure before I speak out of turn. He does. So there is a case out of Hiram Municipal Court that is pending where he was arrested for DUI under the influence of alcohol and driving while license suspended. That was bound over in Hiram in June of 2023. So we're seeing a pattern here that is troubling for the state. Our recommendation is 12 months probation, serve 60 days, credit for time served 15 days. That is from November 28th of 2023, balance probated. We're also requesting ADET, DUI risk reduction, $600 fine, 240 hours of community service, and a victim impact panel. On count 2, the suspended license, that would be 12 months concurrent with count 1, a $500 fine that is statutory, and 6 months additional suspension, which is also statutory. That's all for the state.
So the 6 months is consecutive. You said 6 months additional,
No, the 6-month suspension of his
license
license.
suspension.
That is statutorily
Yeah.
required. Yes.
Mhm. All right. And Mr. McLean, what's your recommendation?
Your Honor, he's asking the court to consider time served on the jail portion of his sentence. That's the only issue he has. Of course, we went over what DUIs are, and the legislature requires certain courses and things as part of a sentence. And he's saying if there's any element other than days in jail that could be increased, he'd be willing to live with that burden and do his probation correctly if he could just ask the court to allow him out of jail now. He needs to get back to a job. He does work in a fast food restaurant as a cook. That's been going on for several months. 6 or 7 months now. And he, as with anybody else, he's got bills and a life to get back to, and he asked the court to have mercy on him and give him time served instead of the extra days, which would have been calculated at 60 divided by 2 is 30. He would have if he had accepted the state's recommendation, he would be agreeing to 15 extra days. And that's what he's asking the court to forgive him on, is the 15 extra days.
In lieu of time served, isn't it a statutory 30 days for a second lifetime, Ms. Fall?
It is, yes, Your Honor, but
Okay.
that can be reduced. But yes, it is a 30-day sentence.
The court is recommending that it would be a consecutive sentence. On the first one, it would be on the DUI, it would be to serve 30 days, credit for time served 15 days. He would report to probation. The fine would be $1,000. He would be subject to an alcohol and drug evaluation. His license would be suspended for 6 months. And you'll need to do 240 hours community service, the risk reduction, and the victim impact panel. And for count 2, it would be a consecutive sentence of one year probation. The fine is $1,000 consecutive. And he will continue to report to probation every month. This is non-reporting. And he will continue to, while he's reporting to probation, he will be subject to random screens for illegal drugs and alcohol. Is that something you'd like to consider?
Your Honor, I'm writing very quickly, if I might just have a moment.
And while you're writing that down, Ms. Fall, this will be a 2-year probation, a $2,000 total in fine, reporting every month with random screens. Does the state have any objection?
No, Your Honor, the only question we had is he will be reporting in the second year as well?
Correct.
Okay, no objection from the state.
Mr. McLean, would your client need some time to discuss this? And then I can take my next case.
I think I better go in the back and speak some more with them about
All right.
the procedure. I think the outlines of the features that we've discussed are in line with what I had in mind. I need to make sure that he and I are of the same mind about how court works.
I totally agree. Thank you. Jail court iPhone, who do we have?
Position number 3.
And Mr. McLean, is there?
Who's next?
Your Honor, this is Tyson Bray from the Public Defender's Office.
Yes, good morning, sir. Are we ready to proceed with Mr. Ballard?
Yes, Your Honor, it is a negotiated plea with Mr. Ballard.
All right, sir, thank you. This is on the jail court iPhone. Sir, are you Arthur Ballard?
Yes.
All right, Mr. Ballard, your case number is 23 CR 77088. You were accused of loitering or prowling and willful obstruction of an officer My name is Judge Law. I'd like to remind you that you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Mr. Bray. Do you see Mr. Bray in the courtroom? If you look at the screen, Mr. Bray will raise his left hand and wave it frantically. There we go. Okay. Oh, is that what you call frantic waving, Mr. Bray? Okay. Do you see your attorney? Mr. Ballard?
Yeah, man.
All right, that's good. Okay, and this is going to be a negotiated plea. So, Mr. Ballard, please raise your right hand. I need to place you under oath, Mr. Ballard.
Oh, yeah.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah, ma'am.
All right, can you put your hand down? Ms. Falk, what's the recommendation for Mr. Ballard?
Yes, Your Honor, the state's recommendation is 12 months probation, serve 42 days, credit for time served 21 days from November 22nd of 2023, balance suspended, stay away from the Quick Trip at 4745 State Route 138 in Union City. Count 2 is 12 months concurrent with count 1. The state would ask the defense stipulate to venue factual basis and identification for the purposes of the plea.
And we will.
All right. Mr. Ballard, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on so far in your case?
Yeah, ma'am.
Are you satisfied with your attorney?
Yeah, ma'am.
And is anyone forcing you to plead guilty today?
No, ma'am.
If you decide to plead guilty, you will not get a chance to have a trial. You won't be able to go back to court, confront your accuser, challenge the people who will testify against you, and challenge the evidence brought against you, and have the prosecution try to carry its burden and prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah, ma'am.
How do you plead to 1 count of loitering or prowling and 1 count of obstruction of an officer?
Yes.
You sound very unsure. If you are unsure, we can schedule your case for trial. So I'm going to ask you again. How do you plead?
Can you ask a question for me?
Sure. How do you?
Well, not guilty.
I'm sorry?
Not guilty.
Okay, so Mr. Bray, it appears that your client wants to have a trial in this case. So I'm going to arraign the case if there's any objection.
Your Honor, could I have a moment to talk with Mr. Ballard? I know he was hard of hearing yesterday. If I could have a breakout room with him, I think we could review what we talked about yesterday.
All right.
On the same page.
Mr. Ballard, can you hear me all right?
Yeah, ma'am.
Okay. Jail court iPhone, we're going to put Mr. Bray, it's Bray, right? B-R-A-Y?
That's correct, Your Honor. And it's Tyson Bray. I
right.
am logged in.
And I see your laptops right there. If you can get to your laptop and we can place jail court iPhone and Tyson Bray's Zoom panel in a breakout, please. Thank you. Mr. McLean, are we ready to resume with your client?
Come on, Mr. Tidwell. Going back to position 28, Mr. Tidwell.
Yes, Your Honor. I just discussed further and in more detail, at least the same amount of detail as we discussed yesterday. And I thought we had a complete understanding. I believe now that we do, as the details of how a plea bargain works. He blanched at the notion of one of the facts that the state believes they can prove. And I told him that, you know, if one side thinks it can prove something, the other side thinks they can't. That's what trials are for. But he understands now what the plea bargain is instead of the trial. He does not wish to risk a trial, and he does wish to accept the leanings the court has on that sentence.
I'm sorry, was it the state's recommendation or the court's recommendation? The state's recommendation is 1 year probation. The court's is 2 year probation. What was your client's decision?
Now that distinction I may have missed, Your Honor. He was simply bringing a non-negotiated plea where he was asking the court for the difference in the jail time.
No, the difference in the jail time is I will give him to serve 30 days, credit for time served 15 days.
Right.
And he will be on probation for 2 years with a $2,000 fine, random screens, in addition to the alcohol and drug evaluation, risk reduction, 240 hours community service, victim impact panel.
Right, that would be an alternative to the negotiated plea would have been
Okay,
60 instead of 30, and that would have
right.
cost.
So I'm accepting the state's recommendation then if he's declining the alternative.
No, he's accepting the alternative. He would like to not do extra jail time.
No.
Okay. Let me be clear. He will be on active probation for 2 years. He will have to report every month. He will be subject to random screens in addition to the other conditions. Mr. Tidwell, is that what you are accepting?
Yes, ma'am.
Are you freely, willingly, and knowingly stipulating to the factual basis, venue, and ID for the DUI charge and driving while license suspended or revoked?
Yes, ma'am.
All right. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Do you again agree that you stipulate to the factual basis, venue, and ID?
Yes, ma'am.
All right. Have you consumed any medicine or alcohol recently?
No, ma'am.
And has anybody, have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Is anyone forcing you to take this plea to offer today?
No, ma'am.
And do you understand that you would have to enter such a plea freely, willingly, and knowingly?
Yes, ma'am.
And you understand that your license will be suspended for the next 6 months?
Yes, ma'am.
And that you are also required to report to probation for up to 2 years every month, in addition to being subject to random screens for illegal drugs and alcohol?
Yes, ma'am.
And do you understand that if you violate the conditions of your sentence, or if you get arrested again for anything else, your probation will be revoked and you could end up serving up to 2 years in prison?
Yes, ma'am.
Are you still entering this plea freely, willingly, and knowingly?
Yes, ma'am.
Mr. Tidwell, do you also understand that if you plead guilty, you will have to give up your constitutional right to a trial? You will not have the opportunity to have a trial in front of a judge or a jury. You will not be able to confront your accuser, challenge the witnesses and evidence brought against you, present any defenses and mitigating factors that you may have if you choose to do so, and have the state to carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
This would be the final decision in your case and there will be no right to appeal. Do you understand that?
Yes, ma'am.
How do you plead to 1 count of driving under the influence of alcohol?
That's what you want to do.
Guilty.
How do you plead to driving to 1 count of driving while license suspended or revoked?
Guilty.
Your sentence is as follows. It will, on count 1, it is going to be 12 months to serve 30 days, credit for time served 15 days, balance probated. You will report to probation every month, beginning with this upcoming Thursday, which is you have to report to probation at 132 Mitchell Street before 3 p.m. While you're on probation for count 1, you will pay a $1,000 fine. You will complete an alcohol and drug evaluation and any treatment that's required. You will complete a risk reduction program. You will complete 240 hours of voluntary community service at any nonprofit agency that is not a church and not a school. And you will attend and complete 1 victim impact panel. You must submit to the alcohol and drug evaluation within 30 days from today and submit yourself to any treatment that's required. For count 2, it will be 1 year of probation consecutive. You will continue to report to probation every month. The fine will be $1,000, and that is a consecutive fine. And during both the up to your 2 years of active probation, you will be subject to random screens for illegal drugs and alcohol. In other words, you cannot consume any illegal drugs and no alcohol while you're on active probation. No driving while your license is suspended. As a result of this conviction, your license will be suspended in accordance with the rules and regulations of the Department of Driver Services. You must surrender your driver's license to your probation officer when you meet him or her on Thursday before 3 p.m. Any questions, Mr. McLean?
I think you might have one small question for me, if I might have a moment.
I have a question, Judge Law. I just want before, and was this now reporting? Thought I heard you say that, but I just want.
Active reporting for up to 2 years.
Okay, thank you.
Officer Brooks, I suppose the random screens will be administered through the probation office at different sites?
That is correct, Your Honor.
Okay, thank you. All right, Mr. McLean, are we ready to proceed? I have another case on hold.
Okay, I'll certainly ask. Your Honor, he lives in Dallas, Georgia, has no transportation and doesn't have the money to Uber at this time. He wondered if he could have a week instead of 2 days to report to 132 Mitchell. By that time, he will have talked to his friends, his family, and figured out a way to get to 132 Mitchell Street. That will avoid having to stay at a shelter for 2 nights in Atlanta, waiting on a meeting.
So he could stay 2 nights in a shelter in Atlanta, report to probation, then return to Dallas. Wouldn't that work?
That would work, but Your Honor, kind of be like almost not being in jail exactly, but
No, that's denied. I need him to report to probation on Thursday and start right away. All right, that concludes this case. Thank you.
Judge, I just have a quick announcement
Yes.
for Mr. Martinez on probations 11 and 12. Are we going to be able to get a Spanish interpreter?
Ms. Strong?
I'll confirm with Mr. Jordan.
All right. If you could please hold, Deputy Francois, Mr. Jordan or Ms. Strong will be in touch with you shortly.
Okay, thank you.
All right. Mr. Bray, are we ready to return to your client's case?
We are, Your Honor. We're ready to proceed with the guilty plea, Judge.
All right. This was resuming with Arthur Ballard. Mr. Ballard, as my last question I was asking you, how do you plead to 1 count of loitering or prowling and willful obstruction of a law enforcement officer? How do you plead?
Yes.
Your sentence is 12 months to serve 42 days, credit for time served 21 days, balance suspended. You are concluded with your sentence in this case, but you are required to stay away from the Quick Trip gas station in Union City. And on count 2, it will be 12 months concurrent. If you return to the Quick Trip where you were arrested, we simply have to bring you back to jail. Thank you.
Okay, thank you.
Position 32, Mr. White. Is that yours, McLean?
yes.
I apologize. What number is this?
32, John White. Is that Mr. White?
Yes, it is, Judge.
All right. This is State versus John White, case 23 CR 7789H. Mr. White's accused of driving under the influence of alcohol and drugs and driving under the influence of alcohol. Ms. Fault, are these per se charges or less safe?
You're on mute.
Excuse me, Your Honor. It is a less safe charge.
Okay. With regards to this case, Mr. White, you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a non-negotiated plea, which means that the state is going to make a recommendation, and then your attorney is going to make an alternative recommendation. Please keep in mind that the court is authorized to accept either recommendation or to disregard either and set the case down for trial. Mr. White, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Full?
Yes, Your Honor. This incident happened November 30th of 2023 at 2250 Holcomb Bridge Road. The defendant was found at that location, slumped in the driver's seat with the keys. The defendant's history is lengthy, and it mainly is drugs and DUIs. So in 2018, he had a conviction for DUI less safe, where he was given a 12 months probation, a $1,598 fine, 40 hours of community service, driver safety, and VI and victim impact panel. 2019, he was given first offender for commission of a felony involving controlled substances and use of a communication device. 2021, he had a DUI drugs and a possession of a Schedule II that he received 12 months probation on the DUI drugs and 3 years probation on the Schedule II offense, which he would still, I believe he may still be serving since the sentence was in 2021. Additionally, he has arrest in 2012 for unlawful possession of identification, furnishing alcohol below a legal age limit. 2015, a DUI of Sandy Springs. 2017, he received pretrial diversion for theft by shoplifting. And 2019, a probation violation and a DUI charge, and on the DUI charge, and in 2022, a probation violation on the use of communication device charge. He also has a fairly lengthy driver's history, including multiple failures to appear in municipal courts in Milton and Roswell, as well as Cobb. So the state's recommendation based on this history, especially because he is currently, as to my understanding, still on probation on that DUI drugs possession of a Schedule II when he committed this new offense, is 12 months probation, serve 120 days in jail, credit for time served 15 days. That's going to be from November 28th of 2023. We are also requesting a balance probated ADET, DUI risk reduction, $1,000 fine, 240 hours of community service, and furthermore, we're requesting an interlock device be placed on his vehicle. We are asking that count 2 merge with count 1 for the purposes of the plea.
Mr. McLean?
Your Honor, in this particular case, it is his belief that this would be the third, is that?
Yeah, I'm cool with it. I mean, I'm fine with the state.
Okay, right, I understand. Similar to the previous thing, Your Honor, but every case is different and every fact pattern is different and every criminal history, of course, is different. He is similarly asking for the court to give him a break on the jail time for a different reason. And his background is different. Your Honor, he does have ulcerative colitis.
Okay.
He takes a drug for it, which is Humira. He was taking that drug. He cannot get that drug in jail. He's afraid his condition will worsen. He has fears that it has worsened. He has fears that it could go into some kind of malignancy, and he wants to stay on top of that. The interlock device would not be necessary for him, he says, because he has finally reached the decision that he's not going to need any driving at all. He will get his transportation by other means. So he's not going to need an interlock device because he's not going to drive.
And how is he going to get to probation?
Go ahead.
Sure. I Uber, whatever I need to do, but I just completed a treatment facility too. And I'm just kind of coming to the realization that I don't need to be on the road for a little bit until I get myself straight out. Yeah.
A little bit means a year.
Yeah.
So, you know, his situation is such that he has come to that conclusion. He asked the court to consider increasing even the fine or the community service, but he does need to attend to his physical needs, medical needs.
I have a bench warrant in this matter that he was released on December 5th. Ms. Falk, do you have any background information on that?
Your Honor,
Looks like he was released on December 5th and then rebooked on the same day.
Let's see.
Was because I have to do it in the hospital instead. Oh, yeah.
Your Honor, he thinks he can explain that to the court if the court would like to.
Go ahead.
So yeah, when they, I guess during the charge, during the arrest, the officer sent me to a hospital instead. And I didn't understand. I waited for a court date, but during that time, I was in Gwinnett County Jail when the court date came up, the failure. So I didn't realize I had a failure to appear because I was in jail while it happened. So they picked me up on the bench warrant, which was for this. And I've been in jail since. Yeah.
All right. Any objection to reducing it to 60 days with credit for 15 days?
Is Your Honor?
Paul?
Later,
No, I'm sorry, I should have addressed this. This is to Ms. Hall.
Wasn't sure who we were. Yes.
And this will be reporting to probation and all other terms in place, and he would have to surrender his driver's license to the probation officer. No driving for up to 1 year.
Right, I understand. Yes, we still object. To me, this is a very different situation than the last defendant who we did recommend 60 days on. This defendant was actually on probation for DUI and drugs when he committed this new offense. So yes, we object.
It's just a different need, Your Honor, and so he would actually be okay with and appreciate if it were 60. It would mean some extra days in jail, 15, I believe, but he could take that.
He would be, I'll reduce it to 60 days, credit for time served 15 days. For the first 6 months of probation, he'll be reporting twice a month. He'll be subject to random screens in addition to all the other requirements set by the state. Is that something he'd like to accept?
It is, I believe.
Yes, Your Honor. I'm trying to do better, so that'd be great.
It's all up to you, sir. So Mr. White, Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
And Mr. White, have you consumed any medication or alcohol recently? Have you understood the proceedings so far?
Yes.
And are you satisfied with your attorney?
Yes.
Is anyone forcing you or inducing you to take this plea offer today?
No.
Are you doing so freely, willingly, and voluntarily? And you do understand that the frequency of your probation reports is increased to twice a month for the first 6 months, and that you would have to voluntarily give up your right to operate a vehicle for the next 12 months.
Yes.
Mr. White, in addition to giving up these rights, do you understand that you will not be able to go back to court and have a trial in front of a judge or a jury? No attorney will represent you in a court of law because you'll be giving up your right to face your accuser, challenge the evidence brought against you, be able to present any defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Okay, the lady appearing on PCD, please mute her screen. Thank you. Mr. White, do you understand that you will also not have a right to appeal since this will be the final decision in this case?
Yes, Your Honor.
How do you plead to one count of driving under the influence of alcohol and drugs?
Guilty, Your Honor.
Repeat.
Guilty.
Count 2 will merge. Your sentence is 12 months to serve 60 days, credit for time served 15 days. You do have additional time left to serve at the jail. And then once you have completed your additional time at jail, you will be placed on active probation. You will report to probation on the first available business day immediately upon release, and that would be either a Monday, a Tuesday, or a Thursday. For the first 6 months of your probation, you will report twice a month. While you are reporting twice a month, in addition to reporting to probation twice a month, you will complete an alcohol and drug evaluation and submit yourself to any treatment that's required. You will complete a risk reduction program. You will pay a $1,000 fine, which must be paid off within the first 6 months of your probation. You will also have the rest of probation to complete 240 hours of community service at any nonprofit agency that is not a church and not a school. I'm dispensing with the interlock device because your license will be surrendered to your probation officer at your first visit, and you are suspended from all driving privileges for 12 months. As I already said, count 2 will merge. Any questions about your sentence?
No, Your Honor.
All right. Officer, I'm sorry. Okay, that concludes this case. Thank you. Jail court iPhone. Oh, I see. Just hold, please. We have an interpreter case. Mr. Martinez, is he?
Come on, Mr. Martinez, he's right here.
Do we have any other cases, Mr. McLean or Mr. Bray, in which a Spanish interpreter is required?
Not that we're aware of.
All right.
We,
Ms. Chauncey, my superhero, and yes, ma'am. if
Good
you-
morning.
Good
Good
morning.
morning, Your Honor. Thank you for that.
Do you solemnly swear and affirm the testimony you provide will be the truth? Excuse me, the translation you provide will be a true and accurate translation with no changes or embellishments.
Yes, Your Honor, I do.
Thank you.
You're welcome.
We have State versus Augusto Martinez, who is facing a probation revocation.
Este es el estado. I'm sorry, I didn't get the name.
Augusto Martinez.
Augusto Martínez, quien está enfrentando la revocación de libertad probatoria.
Mr. Martinez has a right to remain silent. Anything he says in open court, his statements can and will be used against him.
El señor Martínez tiene el derecho a guardar silencio. Todo lo que diga en este caso puede y será usado en su contra.
Mr. Martinez has a right to an attorney. If he cannot afford one, Mr. Michael McLean will be representing him.
El señor Martínez tiene el derecho a ser representado por un abogado y el señor Michael McLean lo está representando.
Mr. McLean, have you shown Mr. Martinez the conviction in his case ending in 22 CR 5970H?
I have not, Your Honor. I can get a copy and show it to him. I will, of course, need some Spanish interpretation for that. I don't speak Spanish.
Estaba esperando a la intérprete para poder mostrarle el documento de su sentencia para poder comunicarme porque no hablo español.
Ms. Chauncey, can you ask Mr. Martinez, does he know the charge of which he's convicted?
Señor Martínez, ¿sabe usted cuál es el cargo que se le está alegando?
No sé nada.
I don't know anything.
Okay. Ms. Chauncey and Mr. McLean, you will need to use Mr. Bray's laptop and go into a breakout.
Right.
Yes, ma'am.
Also, we're also using it to look up the petition itself and Odyssey, all the documents with regard to the case.
Ms. Chauncey?
También tengo que mostrarle a él la petición y otros documentos adjuntos.
He will be in a separate session to speak to his attorney privately with the aid of an interpreter.
Señor, usted estará en otra habitación con la ayuda de su abogado y conmigo la intérprete.
Okay. That's fast.
Okay.
All right. Ms. Chauncey, you'll be placed in a breakout along with Mr. Tyson Bray's laptop.
Se me colocará a mí en otra habitación virtual con usted, señor, y el señor Tyson, que tiene una computadora móvil.
Deputy Francois, can I take up Mr. Bray's cases while Mr. McLean's in a breakout?
We gotta use them.
Yes. You stepped out, Your Honor.
All right, jail court iPhone, who do we have?
I'm sorry, we have on the probation calendar, we have position 7 and 8.
All right, Mr. Bray, is that your client? On the probation revocation matter.
Yes, Your Honor. I do have an announcement for Mr. Durant, which I believe is position 7 and 8. Your Honor, I tried to see Mr. Durant yesterday at the jail, but deputies were unable to locate him. I was able to speak with him briefly this morning, but at this point, I don't feel comfortable going forward with the revocation hearing, given that I've had very minimal contact with Mr. Durant. So I would ask for a continuance to the next court date.
Okay,
So
just
then-
give me a moment.
Yes,
Give me,
Judge.
Officer Brooks, what's the state's recommendation for Mr. Durant?
The recommendation for Mr. Durant is going to be to revoke.
To revoke. Okay, he will need a moment. And how many days does he have left on probation?
131 days.
Okay. All right. Mr. Durant, your attorney is going to speak with you and discuss the terms of the revocation and what the state is recommending. So we will see you on Thursday, this coming Thursday, the 14th, at the probation revocation calendar, after you and your attorney have gone over the terms. Thank you.
Thank you, Your Honor.
All right, here we go. So this, come on, okay, next we have position number 27.
Oh, that's Mr. McLean's case, I think.
We're gonna be waiting a moment before we do the breakout for another deputy to come back, so.
Okay, can you do 27 then?
Yes.
All right, appreciate it. Thank you. Thomas Ross is case number 20 CR 136A. And Mr. Ross is accused of theft by shoplifting. Mr. Ross, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. McLean will be representing you. This is position 27, Thomas Ross. Is that correct? Are you Mr. Ross?
Yes, ma'am.
Okay. And this is going to be this is going to be an arraignment and a request for bond modification. Would that be correct, Mr. McLean?
Correct.
All right.
And Your Honor, sorry to interrupt. The
Go
state
ahead.
did submit an order to Ms. Strong on this case for Your Honor's signature that will dispose of the case.
So this is going to be a null pros?
Yes.
All right. Mr. Ross, the prosecution is not going to proceed with this matter, and the case is closed out. So this case is not holding you at the jail. If there are no other holds, you should be released within 24 hours.
Thank you, ma'am. Have a blessed day.
Thank you.
Thank you.
What's this?
Come on out.
Travis Allen.
Yeah.
We have position number 1, Travis Allen.
All right. Mr. Bray, are you available?
Yes, Your Honor, I had one detail that I needed to update Mr. Allen with. I think I can do that over in front of the court if that's okay, or if the court would prefer a breakout session, I can also do that.
I don't know what the detail is, so I really cannot comment on that. It's really up to you whether you think it's something that needs to be discussed in confidence or whether you're comfortable letting him know a situation in the plea offer.
Yes, Judge. So I'll go ahead and let Mr. Allen know. Mr. Allen, we looked into your incarceration in DeKalb. You were not in DeKalb according to their records at the time that you missed court. Would you like to go forward with the plea that we discussed yesterday?
Yes.
Okay, and Judge, we did review his rights. We went over the paperwork yesterday in preparation for a plea, but we were kind of waiting to determine whether he had been in DeKalb or not at the time he missed court. So we're ready to proceed at this point.
Yeah.
All right. Travis Allen is got 2 cases before us this morning. The first one is 22 CR 4573C, in which he's accused of criminal trespass and fare evasion from a July 16th, 2022 incident. The second case is a bench warrant for his failure to appear, and that's 23 FTA 1104. Allegedly, he failed to appear in court on October 18th, 2023. Mr. Allen, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Tyson Bray. Mr. Allen, may I place you under oath for purposes of the plea?
Yeah, what is the plea?
Well, I'm going to find out, just like you. Are you ready to proceed?
Yeah,
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
yes, yes, I
Thank
am.
you. Ms. Falk, what is the plea offer from Mr. Allen?
Your Honor, this recommendation is on count 1, 12 months probation served 34 days, credit for time served 17 days. That's going to be from July 16th, 2022 to July 18th, 2022 and November 29th to today. That will release him as of today's date. The balance will be suspended, and we are asking that he stay away from all MARTA premises and property. Count 2 would be 12 months concurrent to count 1. And the state would ask the defense stipulate to venue, factual basis, and identification for the purposes of the plea.
And the state will null pros the FTA?
That is correct, Your Honor. We're preparing the null pros so that it can be submitted upon his entry of his plea.
Thank you. Mr. Bray, does your client stipulate to the factual basis, venue, and ID?
Yes, Judge, and those should be the terms of the plea agreement we talked about yesterday with Mr. Allen at the jail.
All right. And just based on your initial statement, he doesn't have any other holds at the Fulton County Jail. Would that be correct?
That is my understanding, Judge.
All right. Mr. Allen, you've already been placed under oath. Did you understand the plea offer and so far what's going on in your case?
So that means I gotta do more time?
So the recommendation is 12 months probation. You serve 34 days, credit for time served 17 days. Based on the concession that the sheriff's office gives you 2 for 1, your jail time is concluded and the remainder of your time will be suspended. So you don't have additional jail time in this case.
So I can be released?
Within 24 hours, but you cannot return to any MARTA property. You cannot use the buses, the trains, and you cannot step on any of the stations.
Yeah, all right.
Would you still like to proceed?
Yeah, we can proceed so I can go home.
But not on MARTA.
All right, then say no more then.
I didn't understand the response. You're not allowed on MARTA. Are you ready to proceed?
Yes, I'm ready to proceed.
Excellent.
Okay.
Have you consumed any medicine or alcohol?
No, I didn't.
And have you understood everything so far?
Yes, I did.
Are you satisfied with your attorney?
Yeah, I'm satisfied.
And is anyone forcing you to take a plea offer today?
No.
In order for me to accept your plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You would have to give up your rights to confront your accuser, challenge the evidence brought against you, be able to present any defenses, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah, I'm trying to go home. I work construction, man. I got 5 kids. I'm trying to get back so I can feed my family.
Are you entering this plea offer freely, willingly, and knowingly, or are you doing so just to get out of jail?
Huh?
Listen very carefully. Listen very carefully.
Yes, ma'am.
Are you entering this plea freely, willingly, knowingly, or are you just doing it to get out of jail?
You said the probation?
I'm going to ask you one last time. Are you entering this plea of guilty just so that you can get out of jail?
No, I'm entering so I can go back to my day-to-day lifestyle and being conductive as a citizen so I can feed my family now.
And are you admitting that you committed the crimes of criminal trespass and fare evasion?
I did not have my bus card at the time, so yes.
So you were trespassing on MARTA?
I had to go to work, ma'am. Yes, ma'am.
But you understand that if you enter this plea that you're not allowed back on MARTA property, so you'll have to find another way to get to work. No, I mean, I can say no to the plea offer and put the case for trial because I'm not convinced that you're pleading guilty. If you're pleading guilty, that means you are admitting that you committed this crime of criminal trespass and fare evasion at a modern property on July 16, 2022. But if you don't want to admit guilty, then I would like you to exercise your right to a trial. Because if you have defenses, then you have the absolute right to present them. And you have the right to have the state try to prove the charges against you beyond a reasonable doubt. So
I mean, ma'am,
I'm going to ask you one last time. Are you pleading guilty just so that you can get out of jail? Or are you admitting that you committed the crimes of which you're being charged?
I'm admitted.
How do you plead? To one count of criminal trespass and one count of fare evasion?
Yes, ma'am.
That's not a response to my question. How are you pleading? To one count of criminal trespass and one count of fare evasion? How are you pleading?
Guilty, ma'am.
Your sentence on the criminal trespass is 12 months to serve 34 days, credit for time served 17 days. The remainder of the time is going to be suspended. You are required to stay away from all MARTA property. That includes the buses, the trains, the stations, MARTA sidewalks, MARTA bathrooms, MARTA parking lots. If you return to any MARTA property, you will be arrested again and brought back to jail. On count 2 is 12 months concurrent. That concludes your case. Thank you.
So could I be released today?
You'll be released within 24 hours if you have no other holds.
Thank you.
Yeah. All right, don't.
Next, we have position, this is on the probation calendar, 1 through 6.
Okay.
29 to 31.
This is Antonio De Jesus. Mr. De Jesus, I don't mean to be rude, but do you understand and speak English?
Yes, ma'am.
All right. You have 6 matters on our probation revocation calendar. And first, I'd like to remind you that you have a right to remain silent. Anything you say about the facts of your cases, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Tyson Bray. Mr. Bray, are we ready to proceed with the revocation matter with the 6 cases involving Antonio De Jesus?
Your Honor, I met with Mr. De Jesus for the first time yesterday, Judge. The probation in his cases, they are asking to revoke the balance. I would ask for one continuance. There's some paperwork that Mr. De Jesus has brought to my attention that I would like to have the opportunity to acquire, so then we can present an alternative resolution in the matter to the court.
I can reset the case to this Thursday if that's adequate time. Otherwise, it will be next Tuesday, which would be the 20th.
Judge, if we could have next
Oh,
Tuesday,
sorry, the 19th. I beg your pardon.
if we could have the 19th, Your Honor, that's the date I would request.
All right. Mr. De Jesus, your attorney would like more time to investigate your matter. And I think that would be a good decision since the probation is seeking to have your entire jail time revoked and serve the rest of the time in prison. So we will see you on December 19th. Same time, same place.
Yes, ma'am. Thank you.
Positions 1 to 6 are reset December 19th.
Okay, next we have position number 6 and 7.
Okay. Mr. Bray's cases 6 and 7. Mr. Bray, what's the announcement for 6 and 7?
Yes, Your Honor. I do need just a moment to speak with Mr. Hong. I don't know how long Mr. McLean will be using my laptop, but I've got one update for him. But I believe it'll be a negotiated resolution after that update, but I just need to confirm with him first.
Would jail court iPhone be able to call courtroom 2? That way, Mr. Tyson will be able to speak to Mr. Hong.
Okay.
All right. I don't know whether you can just pause on the Zoom. I know on the iPhone you can pause on the Zoom and make a call. So I'm crossing fingers and toes that will be the same situation with you.
I would probably have to leave the Zoom and then probably
Go ahead and mute the Zoom and try it. Otherwise, do you have the number for the courtroom too? Okay.
Thank you, Judge.
All right. Mr. Tyson, could you advise Mr. McLean that we're ready to address his case?
I will, Judge.
Miss Fox, somebody promised me that Judge Morrow's calendars are very smooth. So apparently I've been misinformed. So
You have, Your Honor. I think all the calendars on for SAP kind of we're sort of
their moments.
it's very fluid.
Fluid, what a word. Okay. All right, we'll be in recess until either Mr. McLean or do we have any private counsel on the Zoom screen while I'm okay. We'll be in recess until one of the attorneys, Mr. McLean or Mr. Tyson appears. Francois, how are we doing on Mr. McLean's case? I think he said enough time. He said enough time. Tell him is either showtime or reset.
I'm sorry, what did you say, Judge Law?
I think tell Mr. McLean I'm ready to address his
They
case with Mr.
can't find McLean. I don't know where he went. Judge.
What? How can you lose an attorney?
I don't know. But the only case we have left for McLean is Mr. Warner. That's position.
Okay, give me a moment. Give me a moment. Miss Strong, Mr. McLean's in the breakout. Tell him the judge is requiring him to come back to the main session.
Yes, ma'am.
Thank you.
Thank you, Judge Law. We can't find him.
Is there a Davian Monea Brown or a Jarvis Davis on Zoom at the present time? That would be the calendar for 11 o'clock.
Yes.
All right. And what's your name, sir?
Jarvis.
Say your name again.
Jarvis Davis.
All right. Mr. Davis, start your video.
Judge, you said it again, Judge?
Start your video.
Yes.
All right. And Mr. Davis, just 1 second. Ms. Strong, we can rename the Zoom panel to Jarvis Davis, common spelling. Mr. Davis, you have a right to remain silent about the facts of your case. Anything you say, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you. Do you have an attorney?
Yes, Michael Claim at the moment.
Michael, what's his last name?
McLean,
Oh,
MC.
McLean, okay.
Yes,
All right, Mr. McLean, and have you had a chance to speak with him regarding your bench warrant matter?
I did, Your Honor.
Okay, so, Ms. Strong, let's go ahead and rename his screen to Jarvis Davis. And as soon as Mr. McLean is concluded with his cases on the morning calendar, we'll be able to address yours. So I just wanted to make sure that you are present. Okay,
Yes.
all right, you can mute your screen and stop your video presently. Is there I think it's Davian Monea Brown? All right, we're gonna hold on that. Mr. Bray, Mr. Tyson, did you get your laptop back?
Your Honor, I have not, but I was able to speak with Mr. Boyd, position 7 on the all-purpose calendar. And we're ready to proceed with the negotiated plea whenever the court is. Position 6 and 7, excuse me.
Thank you, sir. Jail court iPhone, it needs to come back, so if the host could please check and see if they're in the and that's gonna be a negotiated plea?
That's correct, Your Honor.
And is there a language issue?
Your Honor, he has told me that there is not, and we're able to have a meaningful conversation, though I would, just of course, if he has any issues or concerns, that may be something, but I haven't had any problems communicating with him so far.
All right. Thank you, Mr. Tyson. Jail court iPhone, we have Mr. Hung Bui, B-U-I, and his case number is 21 CR 3344E, in which he was accused of battery from July 11, 2021. Mr. Bui, can you hear me?
Yeah.
Judge Law? All right, good. Mr. Bui, are you able to understand what I just said?
Yes, ma'am.
All right. Do you speak and understand English enough to understand what I'm saying?
Yes, yes,
Okay,
yes, ma'am.
good. And Mr. Bui, you have a second case. It's a bench warrant in which you were alleged to have failed to appear in court. The case number is 23 FTA 1097. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Tyson is your counsel. Mr. Bui, would you please raise your right hand for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You need to say yes or no.
Yes, ma'am.
Thank you. Ms. Falk, what is the recommendation for Mr. Bui?
Your Honor, the state's recommendation is 12 months probation, serve 68 days, credit for time served 34 days, from July 11th, 2021 to July 28th of 2021 and November 27th of 2023 to today. The balance will be probated. No further contact with Tyrone Walker. Stay away from 309 Edgewood Avenue, Atlanta. 8 weeks of anger management, 40 hours community service, and the state is agreeing to null pros position 7, which is the failure to appear.
All right. That was Tyrone Walker, correct?
Yes.
All right.
And the state would request that the defense stipulate to venue, factual basis, and identification for the purposes of the plea.
We will.
Mr. Bui, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood everything in your case so far?
Yes, ma'am.
Are you satisfied with your attorney? Are you happy with your attorney?
Yes, ma'am.
And is anyone forcing you to plead guilty today?
No, ma'am.
If you decide to plead guilty, you will not get a chance to go back and have a trial. You will not be able to confront your accuser, challenge the testimony of witnesses brought against you, and the evidence brought against you. You will not be able to present any defenses, and you will not be able to have the state, the prosecution, try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of battery?
Guilty, ma'am.
How do you plead to 1 count of battery?
Guilty.
Your sentence is 12 months to serve 68 days, credit for time served 34 days. Your jail time in this case is over, but you must report to probation. If you are released within 24 hours, you must report to probation this Thursday. Today's Tuesday. So you must report to probation on Thursday at 132 Mitchell Street before 3 p.m. Do you understand?
Yes, ma'am.
While you're on probation, you will complete 40 hours of community service. You are to have no contact with Tyrone Walker, stay 200 yards away from Mr. Walker, and not speak to him in any way, form, or manner. You're also not to return to 309 Edgewood Avenue in Atlanta, Georgia. If you return to that location, you will be arrested again. Do you understand, sir?
Yes, ma'am.
Your bench warrant case will be closed out. Thank you.
Thank you.
Right. Mr. McLean, are we ready to proceed with Mr. Martinez?
Yes, Your Honor, we made some real progress with the breakout room.
Yeah. Ms. Chauncey, are we ready to proceed?
Yes, Your Honor.
All right. Mr. Martinez, you have been advised of your rights. Do you understand the charge of which you've been convicted?
Señor Martínez, a usted se le han explicado sus derechos. ¿Usted entiende los cargos por los cuales las convicciones que ha recibido?
Sí, estoy entendiendo, pero ha habido muy mal entendido.
Yes, I am understanding, but there has been misunderstanding too.
All right. First of all, Officer Brooks, are you present?
Señor Oficial Brooks?
Yes, Your Honor.
All right. Mr. Martinez, you're already convicted of that offense. The question we have to address today is whether you have to serve jail time or whether we continue you on probation.
Señor Martínez, la pregunta que tenemos hoy en este momento es que si usted continuará en la cárcel o con su libertad probatoria.
Do you understand that is why you are here today?
¿Usted entiende que ese es el motivo por el cual está usted aquí hoy?
Sí, yo quiero seguir con mi probatoria.
Yes, I would like to continue my probation.
Okay. Mr. McLean, the state is recommending that his probation be revoked, but he's got 11 days left on his probation.
La fiscalía, señor McLean, está pidiendo que se revoque su probatoria y le quedan 11 días de probatoria.
He's already served 14 days, which would be commuted to time served.
Él ya ha servido 14 días, los que se le dará crédito al señor.
Which means, let me finish, which means this case would be marked as a probation violation.
Lo que este caso será declarado como un incumplimiento de probatoria.
And his obligations for this case are over.
Y las obligaciones sobre este caso quedarán concluidas.
Your Honor, I think that would be suitable, and I think Mr. Martinez will agree that that is suitable. I do wish to add before we go that he wanted the court to know he tried. He went to 3 different addresses at which he was told there would be Spanish-speaking classes available. He said that despite his best efforts, none of the addresses were good. He walked around so much, some of it in the rain, that his left leg looks, his lower left leg, the lower half of his calf and shin look terrible. They have an ulceration on it where you see red. He said the previous public defender spoke to him at a time when it was actually bleeding.
Mr. McLean, I'm so sorry to pause you, but Ms. Chauncey would have to translate all that.
Thank you. Su señoría, me parece, estoy de acuerdo con la decisión y el señor, mi cliente también creo que él va a estar de acuerdo. Él quiere que yo le comunique que él intentó cumplir. Él fue a 3 lugares diferentes que se le dieron en donde hablaba español, pero ninguno de esos domicilios eran correctos. Él caminado bajo la lluvia y tiene una lesión muy grande en la pierna izquierda, en donde se ve de una manera horrible, con úlceras y enrojecida. La anterior abogada pública también mencionó esto. Thank you, Mr. McLean. Go ahead, please.
Thank you. I'm sorry, I was,
No, that's all right.
myself.
It happens.
So, Your Honor, his belief of what was argued for him before has a result very similar to what Your Honor is proposing. And I think that ending the case, even with the unfortunate disadvantage that counts as a unsuccessful completion.
Creo que como anteriormente se propuso de manera similar, es muy conveniente terminar este caso que a pesar de los resultados que fueron incompletos.
So, Mr. McLean, in your breakout, as your client represented to you that he's willing to accept the court's recommendation?
Yes, Your Honor.
Señor, cuando estuvimos en la otra habitación virtual, su cliente le dijo que él está dispuesto a aceptar la recomendación que estoy dando. Sí.
Yes, Your Honor.
This
Sí,
is a probation violation. He's got 11 days left to serve, which is commuted to time served. That concludes the case. He will be released with no further obligations.
Entonces, incumplimiento de probatoria se está actualmente con 10 días a servir que se le otorga por ese periodo de tiempo como tiempo servido, y esto concluirá el caso.
Thank you, Your Honor.
Thank you.
I'm sorry, sin tener que cumplir ninguna otra obligación más. Thank you.
All right. Thank you. Jail court iPhone, as I've already confirmed that there are no other cases requiring a Spanish interpreter, may I release Ms. Chansey?
Yeah, we're good on the iPhone.
All right. Deputy Francois? Any need for a Spanish interpreter?
No, you
All right.
don't.
Ms. Chansey, thank you so much.
You're
Appreciate
welcome,
it
Your
again.
Honor. My pleasure.
Have a good day.
You
Thank
too. Bye-bye.
Bye-bye. All right, jail, Francois, did you want me to address the jail or jail court iPhone?
Either or is fine, Judge.
Okay, let me start with jail court iPhone. Who do we have?
On a probation calendar, we have positions 9 and 10.
This is State versus Kevin William Finley. And Mr. Finley has got a conviction in case 21 CR 696A of battery family violence. He's got a probation revocation here case 23 PV 1630. Mr. Finley, you have a right to remain silent, and anything you say about the facts of your cases, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Tyson Bray. Ms. Officer Brooks, you're still under oath. What's the revocation basis for Mr. Finley? Officer Brooks? Oops. Oh dear. Officer Brooks, I think your Zoom panel is frozen. If you could refresh. Oh, give us a moment. Officer Brooks is going to rejoin the Zoom. All right, in addition to Mr. Finley, I believe that then concludes the probation revocation calendar.
Can you hear me now?
Yes, Officer Brooks, thank you.
Thank you. My apologies.
No
Your Honor.
problem. You're still deemed to be under oath. What's the revocation basis for Mr. Finley?
Yes, Your Honor. He was seen in court on February the 9th of 2023, and he was court ordered to complete the Family Violence Intervention Program. He reported on March the 2nd. He only reported that one time. In April, our calls were blocked. We sent out a letter for a revocation hearing, which he failed to appear for on July the 27th. and a warrant was placed.
All right. How much time does he left in probation?
He has 196 days remaining, Your Honor.
And the state's recommendation?
We're recommending to revoke. He hardly has enough time to complete the domestic violence program, Your Honor.
All right. So the recommendation, he served the rest of the 196 days in jail.
It is.
And, how much time has he already served in jail? This is Mr. Tyson. Do you know how much time your client's already been in jail?
Your Honor, the offer that I had received from probation yesterday said that they were recommending that he return to probation and complete the class, since I do believe he has the time. I spoke with him yesterday, and Mr. Finley was in agreement that he wanted that treatment. So, Your Honor, at this point, I haven't gotten enough background information to provide the court with mitigation. My understanding is that we had an agreement about what to do in Mr. Finley's case.
All right. Officer Brooks, has there been a change of position from the state?
That would be my position. However, it does appear that whomever he spoke to yesterday from our office did recommend to continue and enroll within 7 days. I don't know if they're aware that our phone calls were blocked and he only reported one time, so I look at it differently. So I'll defer to the court.
Okay. He's been in custody now for 16 days. So he really has 180 days left to serve on probation. I'm going to give him credit for the time that he served, which means that he has to complete a 24-week program, which means that he has to enroll in that program within 14 days of being released. And I don't know whether he's going to get into any school in order to finish the rest of the time. So we are, it's very, very tight, Mr. Tyson, and your client has deliberately prevented probation from having any contact with him. So I'm a little concerned about that. He can still go MIA again.
Yes, Judge. When I spoke with him at the jail, he indicated to me that he would like to go forward with the treatment. I can provide him with a list of
No, I'm trying to address why did he block probation?
Yes, Judge. That was not listed on the petition, so I was unaware of that allegation.
Okay. Ms. Brooks, where do you get the information that probation's numbers were blocked?
I did a case file review this morning prior to court, Your Honor, and I saw where it was indicated in the case that phone calls were blocked, and how our system is set up for when we reach out to probationers. You know how on any phone you can press, like they give you the option of 1 or 2. It shows us on our end when somebody intentionally blocks our calls.
Okay, just give me a moment.
And it would actually be text messages, Your Honor.
All right.
That they block.
This is Mr. Finley's second probation violation. He was previously addressed by Judge Roth on July 17th, 2023. Given the circumstances and the narrow time frame, the court is accepting the state's recommendation, revoking the remainder of time, giving him credit for the 16 days that he's been served in jail, and requiring him to complete the remainder of the 180 days, which means he has 90 more days to serve at the Fulton County Jail before his obligations in this case are completed. Thank you.
Judge, next we got positions 29 through 31, Mr. Warner.
Honor.
Officer Brooks, let me just confirm. Francois, I don't have any more revocation cases. Do you confirm that? And jail court iPhone, can we confirm that?
This is our last case for Mr. McLean here in courtroom 2.
Okay.
I don't have any more other cases.
All right. Oh, I have one at jail court iPhone. So I'm just going to release Officer Brooks since I don't have any revocation matters. Do you concur, Officer Brooks?
Yes, Your Honor. Thank you so much.
Thank you. All right. Mr. McLean, could you tell me your client's name again?
Brandon Christopher Warner.
Warner. Okay, thank you. Mr. Brandon Warner has got 3 matters before us. One of them is a bench warrant for failure to appear in case number 23 FTA 1107 from January 6, 2023. The 2 open cases against him are as follows: 21 CR 2987D, 1 misdemeanor count of stalking from May 15, 2021. And the second case is 22 CR 6102D, a loitering and prowling charge from October 6, 2020. Mr. Warner, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. And this is, well, it looks like it's a waiver of, it says the cases are to be arraigned, and there's a bond modification request. Would that be correct, Mr. McLean?
Yes, Your Honor. He would like to go on to the trial calendar and address these in the trial court. He feels he will be vindicated. His main argument, Your Honor, in favor of a bond modification at this point is that the allegation of one is from the spring of 2021. The other is from the fall of 2020, even prior to that. And he says that he has not been accused and has not gotten any trouble since these accusations, which he says are incorrect anyway. So given that, Your Honor, he asked the court to give him a signature bond if possible.
And he does understand that the cases have been in a dormant state because he failed to appear in court on January 24th, 2022.
He
In
does.
that case then, okay. No, I just wanted to be sure.
Right, but
Mr. McLean, do you waive a reading of the accusations?
we do.
All right, sir. Mr. Warner, as I've already indicated, you do have 2 open cases with regards to misdemeanor offenses and 1 open case for failure to appear. In the, as your attorney has waived a reading of the accusations, you do have 2 underlying misdemeanor offenses, which are stalking and loitering and prowling. Upon your entry of a not guilty plea to these charges, including the bench warrant for failure to appear, your cases will be scheduled for trial. At the time of the trial, you will have the assistance of counsel in order to face the prosecution, who has the complete burden to prove the charges against you beyond a reasonable doubt and overcome your legal presumption of innocence. However, if the state does prevail and does carry its burden of proof, you could be convicted of 1 or more of these offenses and face a penalty of up to a year in jail and or up to $1,000 fine for each convicted offense. Given this information, how do you plead? All right, sir. Your cases have been arraigned and they're going to be further noticed for trial with respect to all 3 matters. In the meantime, with respect to your cases, there is a current bond of $3,000, which is $2,000 for the bench warrant and $1,000 for the stalking matter. He's got, I guess, a signature bond on the loitering and prowling, which,
Right.
So yes, Mr. McLean, why should I reduce the bond?
Your Honor, just simply that he has, while I'm not addressing the fault or non-fault regarding the lapse of time, he has not been in any trouble since, and that bodes well for for any concern the state could have, as they often say, that somebody's going to commit an offense in the meantime. That's not likely here.
All right. I think I do have pretrial on Zoom. Yes, Ms. Tyson, do you have any a GCIC on Mr. Brandon Christopher Warner?
Yes. Mr. Warner, he has 5 arrest cycles out of Georgia, no felony convictions. It appears he may have a pending case out of Henry County for battery, family violence, and willful obstruction. GCIC states that a warrant was issued May of 2022. And I guess he put in a not guilty plea. See, September of 2023, but no other disposition is listed on the GCIC. He has a total of 3 FTAs He has one cycle out of California, and that's from 2012. Looks like that was for robbery, carjacking. Yeah, robbery in the second degree, carjacking, and a failure to appear, which resulted in a felony conviction for the carjacking. Disposition date on that was August of 2013. And it looks like he has one cycle, let's see, out of New Mexico. And that's from 2011. It's for a contempt of court misdemeanor. No dispositions listed on the GCIC. Nothing to add, Your Honor.
I do have a question on the Henry County 2022 matter. What's the date of allegation?
Your Honor, it appears the date of the allegation on that case is, the arrest date was September 29th, 2021, but we're showing on our GCIC that a failure to appear was issued for him on what he was arrested on a failure to appear July 7th, 2022.
All right.
So I would, if the allegation is from September 2021, Your Honor, my previous remarks would be off by 6 months.
Okay.
Well, let's see.
But let Ms. Falk respond to your request for bond modification. Yes, Ms. Falk.
Yes, Your Honor. So a couple of things. I want to point out that he actually missed court 2 separate court dates. On the 21 CR case, he was given, his bond was modified to a signature bond on August 4th, 2021. He then failed to appear on January 14th of 2022, at which point that bench warrant was issued for him. On the 22 CR case, the loitering prowling, the bench warrant was issued after he failed to appear for court on January 6th of 2022. So he actually missed 2 distinct and separate court dates. They weren't just kind of all rolled into one and he just missed one. Secondly, I want to point out that he also failed to appear in Henry County. So there is a pattern here of failure to appear. It wasn't just a one-off. We now have 3 different failure to appears, 2 in Fulton, 1 in Henry. I'd like to further point out that as far as the facts of the case, we are concerned the first incident happened October 6th of 2020, and that was the loitering, first incident, yes, happened in 2020. That was the loitering and prowling. Officers were called out to 718 Fraser Street, spoke with Miss Kathleen Kennedy and Miss Sydney Merritt, who stated she had been in the bedroom speaking when she heard the back door open and close. She didn't think anything of it, stepped out for a cigarette break, and she said after that, her bedroom door began to open slowly, and she saw a man in the doorway who was not her male roommates, but an unknown male she had never seen before in her life. She stated the man said nothing at all during the interaction, stared blankly at her before closing the door, turning back toward the back door and leaving her house. At that point, officers were called and placed the defendant under arrest. In the second case, which happened May 15th of 2021, officers responded to 718 Fraser Street in reference to a dispute between neighbors. Heather Chapman, the victim, stated that she was advised the defendant was walking out of his home. The defendant stated, "You thought I killed your daughter." And the defendant had been issued a previous criminal trespass warning for coming onto that property at 718 Fraser Street. The defendant was also seen on video following the victim to her vehicle while being in her face. And at that point, the victim had also signed a petition for stalking against the defendant at that location. As far as we did attempt to make contact with Miss Heather and Sydney Merritt and Miss Kathleen Kennedy, and we would like to sound for them. But I don't think it is a compelling argument that, well, the case is so old, why should we even bother, because he's managed to evade service and evade arrest for this long. Again, the history is one of FTA, and as well as offenses against women in particular, both the stalking and the loitering and prowling. We do ask that those bonds remain the same. 2,000, I believe, was the 22 CR case, and 1,000 on the stalking offense. We ask that those bonds remain as set until the defendant goes to trial or proceeds to a bond hearing before the judge that is handling both of those cases, I believe Judge Edline.
I'm sure the court will recall that was not my argument, actually, but he does inform me that the Henry County matters were resolved in his favor.
Understood. Well, unfortunately, not as clean a record as I was anticipating. On the position 30, in which Mr. Warner is accused of stalking, the bond is amended to a $2,000 surety bond. And no contact, all other conditions set forth in Judge Edline's order of August 4th, 2021 shall remain the same, including staying away 200 yards away from 718 Fraser Street, Atlanta, Georgia, and having no contact with Heather Chapman and Sydney Merritt. With regards to position 31, in which he's accused of loitering and prowling, the bond is amended to $1,000 surety. Again, stay away from 718 Fraser Street in Atlanta, Georgia, would be, and all other conditions remain the same. With regards to the failure to appear, I'm amending that to a $3,000 signature bond through the jail. So these are the cases have been arraigned. The bond remains as a total of $3,000 surety bond with following conditions. Mr. McLean, I will submit the proposed order for all three cases, and the cases will be further noticed for trial before Judge Edline.
Understood.
Thank you.
And Your Honor, the state is revoking their previous offers on both cases.
Understood. Thank you. All right, Mr. McLean, I think that concludes your cases in on the SAP calendar.
It does. Well, I have some AC/DC clients.
I don't see them on yet, but I have jail court iPhone. Who do we have?
I have positions 8 and 9.
All right. Mr. Bray?
Your Honor, that is actually a conflict from our office. I believe that's Ms. McLeod's client, Your Honor.
All right. Mr. Anthony Cantu Davila? Your attorney is Ms. McLeod, and I don't see her on the Zoom. Mr. Jordan and Ms. Strong, any updates?
Yes, ma'am. Ms. McLeod asked if this case could be reset to next Tuesday. She's in a trial with Judge Roth this morning.
All right. Mr. Cantu Davila, your attorney will be available to address your case on Tuesday, December 19th, same time, same place. Thank you. All right. With regards to the SAP calendar, I'll go over the announcements shortly. Oh, I'm so sorry. Is jail court iPhone? Do we have another case?
Yes, I'm sorry. We have positions number 17.
Okay.
Yes, last name Hambrick, first name Roshan.
Yes, sir.
Your Honor, I apologize, Your Honor. Mr. Hambrick is my client. If I could have a breakout room with Mr. Hambrick for just a moment, again, it'll be very brief, Your Honor.
All right. You will need to use your laptop.
I will, Judge.
All right. And jail court iPhone, you will see a message on your screen to join a breakout. Or you can go back, well, wait for the message because I don't know which breakout room you're in. Mr. McLean, we have your client on Zoom, Mr. Jarvis Davis. And I see that Ms. Dwayne Brown has also joined the Zoom. Mr. Davis and Mr.
Hey, Judge, I'm still on this, Jarvis Davis.
All right, that's good. And Ms. Dwayne Brown, okay? Ms. Dwayne Brown and Mr. Jarvis Davis, you are here because a bench warrant has been issued against both of you in your respective cases. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney if you cannot afford one, and one will be appointed to represent you. Mr. McLean, do you represent Mr. Davis?
Your Honor, I've in bench warrant situations on DV calendars, what we do is we ask them about their income. We tell them that we will represent them and speak for them in this hearing, but we do note that in the future, he works full time. It does not appear that he will qualify for the public defender's services going forward. But today, Your Honor, I can speak for him.
All right, Mr. Davis, I understand that you've already spoken to Mr. McLean. Ms. Dwayne Brown, please unmute.
It's Divine Brown.
Divine Brown. Okay, thank you. Ms. Brown, have you spoken to a public defense attorney or do you have your own attorney?
Yeah, I spoke with him yesterday. What was his name? Let me see.
Michael McLean.
Yes, I did. Tyson Bray. I spoke
Oh,
with him
you spoke
yesterday.
to Mr. Bray. Okay, then
Right.
please hold until Mr. Bray is available.
Okay.
Thank you. Jarvis Davis's case is 23 CR 5694Y, accused of battery family violence from August 17, 2023. Mr. Davis, case was accused. Excuse me, just one second, please. On August 30th, 2023. And he had a plea and arraignment calendar before Judge Edie, which he did not appear on November 8th, 2023. Hence, a bench warrant was issued. Yes, Mr. McLean, why are we seeking to set aside the bench warrant?
Your Honor, he did not get notice of the of the date that he missed. He has looked into as best he can, looked into the addresses that were current at the time in the knowledge of the court system, and does not have a reason. Sometimes the mail fails. He doesn't know why he didn't get notice of that. I have advised my clients in general that one should never rely upon U.S. mail for their freedom and should always go to the court for in person every 2 weeks by foot. And that'll cause a person never to miss a court date. Your Honor, he's active in community organizations. He has a record that the state may read, which is considerable, but he has also taken part in the program called, let's see, My Journey Matters. It's, Your Honor may be familiar with that one. He is active in that and other community organizations for youth.
All right, thank you. Ms. Tyson, does Mr. Davis have any other open cases? I just noticed something from November 17th, 2021. Looks like it might be a Superior Court matter. And in 2017.
I don't have anything from 2021. I don't see anything on the GC. I see the previous arrest was out of Cobb County, and that was in 2020 before this case. And he did have a felony matter that was in 2009, and he received first offender treatment on that case, and it was sealed in 2016.
Okay.
I don't see, at least from my end, I don't see anything else.
All right, I just see 21 CP 204578. Looks like the case has been closed.
That case was dismissed, Your Honor.
All right, and 17 SC 155665.
And Your Honor, I'm showing that case was null prost on October 16th of 2020.
All right, thank you. Ms. Fault, any objection to setting aside the bench warrant and having him report back to court?
Yes, Your Honor, my main concern is that he bench warranted about 3 months after he was released. So he was released in August, I believe, and had bench warranted before Judge Edie by, let me just double check my date on this one, by November of 2023. And so the state does have some concerns about him returning to court. And we do object to lifting that bench warrant at this time. It was November 8th, 2023 when he failed to appear, which was less than 3 months after he was released on this case.
All right.
Your Honor, can I speak on this matter, please?
Mr. McLean?
Extremely briefly, please. Just very brief.
Your Honor, there were that too in November of 8th. I missed the court because of the technical issue with the mail. But when I went to court 3 months prior, I was incarcerated. That's why I could not go to court. So that's that reason.
All right, thank you. I'm going to set aside the bench warrant, and Mr. Davis, this will be marked as an FTA on your record. Please keep in mind that it is your responsibility to make sure that you get notices through the mail. If there is an issue with the United States Postal Service, that's an issue that you have to resolve. It's not the court's concern.
Yes,
The due process requires us to put it in the mail and that it gets to the address that you have provided. So I see that we have a new address for you right now, somewhere in Hank Aaron Drive. Would
yes.
that be your current address?
That's my current address, and I would do what Mr. McLean said. I will be going to the courtroom weekly to make sure I never miss another court date.
Not weekly. Bi-weekly is fine. And
Weekly.
the
And
court.
Mr. McLean, his bond is modified to a $3,000 signature bond through pretrial services. In addition to keeping up with his court dates, he must report to pretrial once a month. If he does not report to pretrial, if he does not appear in court, if he gets arrested again for anything else, the signature bond that I'm presently issuing will be revoked and amended to a $3,000 cash bond only.
Yes, Your Honor.
All right, Mr. Davis, I mentioned your prior cases because I want you to know that I know this is not your first rodeo. All right?
Yes.
And it is your responsibility for keeping up with court dates and keeping up with notices. Thank you.
Yes.
You're
Yes.
free to
I
go.
must-
Mr. McLean, can you please send me your client's contact information also?
Well, let's make
Or
this
he can put
easier.
it in the
Let's
chat.
make this easier. Mr. Davis,
Yes.
please put down in the chat feature, please
Yes.
direct that to a.tyson-pretrial.
A. Tyson.
Yes. Put down your full name, your current mailing address, including apartment number, your phone number, and your email.
Yes.
And then Mr. Davis, once Ms. Tyson confirms receipt, then Ms. Tyson, you may release them from the Zoom.
Yes, Your Honor.
Thank you. All right, Mr. Davis, do not go until Ms. Tyson gives you the green light.
I will not.
Thank you. All right, we are addressing Ms. Brown, case number 20 CR 004509G. She's accused of battery family violence from August 24, 2020. Ms. Brown's case was accused and she had a court date on December 7th, 2021 with regards to Judge Mather's calendar. Looks like a warrant was issued for failure to appear. She was arrested and made bond on April 22nd, 2022, provided a signature bond through the jail. Has her bench warrant already been closed out by an arrest?
Your Honor, I believe it may have been. When looking at this one, I'm a little confused because it shows that the arrest warrant was issued December 20th of 2021. She was then given an SOB jail bond April 22nd of 2022. The arrest warrant was then voided December 5th, 2023 on the clerk's record. And she actually never went back into our jail. I went back and looked at jail manager. Her only arrest in our jail is the August 2020 arrest. So she never went back in the jail when they did the SOB jail bond in 2022. I don't believe there is a bench warrant at this point, but I just want to confirm that because what I'm seeing is that it was voided on December 5th, 2023, but I can't access the documentation.
All right.
May I speak? Shall we?
No. There is a open active case against Ms. Brown, and Ms. Brown's current address is a New York address. Is that your current mailing address, Ms. Brown? Okay. This is still an open active case, and notices will be sent to you at this address. You will need to appear in court. Since this is a case with Judge Mather, I don't know whether you'll be required, you are permitted to appear via Zoom, so you just have to assume that you're required to appear in person. Mr. Bray, please submit a proposed order that dismisses any pending bench warrants in this case at present.
Yes, Judge, I'll prepare that.
All right. Anything, Ms. Brown, you're free to go. And jail court iPhone, who do we have?
We have position number 17.
Okay.
Is Mr. Hambrick, Your Honor. I've had the opportunity to speak with him. through a breakout room, and he wishes to proceed with a negotiated plea.
All right. Roshan Hembrick's case is 23 CR 7470A, accused of loitering and prowling and willful obstruction of a law enforcement officer. This is from November 27, 2023. Mr. Hembrick, you've been advised, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Bray. May I place you under oath for purposes of the plea?
Yes.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Polk, what's the recommendation for Mr. Hembrick?
Yes, Your Honor. It is on count 1, 12 months served, 30 days, credit for time served, 15 days from November 28th of 2023, balance suspended, stay away from 136 Walnut Street in Atlanta and no further contact with Dolores Harper. On count 2, 12 months concurrent with count 1, we did have an opportunity to speak with Ms. Harper. She does agree with the plea offer, and she did state she would not be present today, but we would like to sound for her in an abundance of caution.
Dolores Harper? All right. And Mr. Bray, do you stipulate to the factual basis, venue, and ID?
I do, Your Honor.
Okay. And Mr. Hembrick, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And if you decide to enter this plea, you would have to give up your constitutional right to a trial. You will not be able to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am. Like, what do you? Yes, like, what do you mean? You said,
If you decide to plead guilty to the 2 charges brought against you, you will not have a trial in a court of law. You would have to give up your right to a trial, to confront your accuser, challenge the evidence brought against you, and give up your right to have the prosecution carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of loitering and prowling and willful obstruction of an officer?
Guilty.
Your sentence for the loitering and prowling is 12 months to serve 30 days, credit for time served 15 days, balance suspended. Your jail time for this case is concluded. You cannot return to 136 Walnut Street in Atlanta, Georgia, and you have to stay away and have no contact with Dolores Harper. Your sentence for the obstruction charge is concurrent. Thank you.
All right, next we have position number 25.
Okay. Any word yet from ACDC? Any chance? No? Okay. This is
Sorry,
Mr.
sorry, Your Honor. Did they say 25? Because I thought we addressed that case.
Yeah, 24 and 25. What's his name, officer?
I'm sorry, I think this is McPherson. Is that 23?
But that's 23. That would be correct. Yes. All right. Mr. McPherson, can you hear me?
Yes, ma'am.
Can you see me?
Yes, ma'am.
All right. Can you see your attorney, Mr. Michael McLean, who is sitting on a chair right now?
Yes, ma'am.
All right. You need to pay attention to the screen so that you can understand what's going on. Mr. DeMarcus McPherson is accused of criminal trespass, willful obstruction of an officer, and theft by shoplifting from October 22nd, October 23rd, and November 17th of this year. These 3 incidences are accused under case number 23007, 23 CR 007709E. Mr. McPherson, you have a right to remain silent about the facts of your case. Anything you say can and will be used against you. You have a right to an attorney, and Mr. McLean is your counsel. Mr. McLean, how are we proceeding in this case?
This is a plea, Your Honor.
Mr. McPherson, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes. Yes, ma'am.
Ms. Falk?
Yes, Your Honor. I just have a quick question. Is this a plead to both cases or just the one?
I have only one case listed unless it's on a different position number.
Right. I placed a note in the case when I submitted it to Mr. McLean and to the court, when we submitted our recommendations, that the defendant had an additional case, 23 CR 007432E. It's a family violence battery, and the state offered essentially a global recommendation as to both.
All right, it's my bad then. I didn't put a note on my calendar on that. Let me, Mr. McLean, you can put your hand down, Mr. McPherson. Mr. McLean, is it your understanding that we are addressing both cases?
It is, Your Honor. Both recommendations in the negotiated plea are the same.
All right.
Except for additional probation matters in the other one of FVIP and 40 hours.
All right, that was my mistake. Mr. McPherson, it appears that we are addressing two open cases against you. The first one was for the trespass, the obstruction, and the shoplifting. And the second case would be from a September 15th, 2023 incident. And that case number is 23 CR 7432E, in which you were accused of battery family violence. Is it your understanding that we are addressing these two open cases against you?
Well, I thought, I went to court for the family violence, and I got a signature bond on that. So I ain't really confused now.
Do you remember our discussion of a 24-week course, what it is likely to cost when you find the provider that is suitable for you when you shop around, how long it will take, how important it is not to skip or get dropped out because you'll have to start all over. You remember that discussion? That has to do with the battery family violence case as opposed to the criminal trespass case. That's called FVIP, Family Violence Intervention Program.
All right, if Mr. McPherson doesn't want to plead to the battery family violence, then the global offer is off the table, and I can arraign both cases so that all the cases can be scheduled for trial. Mr. McPherson, there is no offer unless both cases are involved. So presently, there is no plea offer. Would you like your cases to be scheduled for trial?
Yes, ma'am.
All right. Mr. McLean, do we waive a reading of the accusation?
Not at this time, Your Honor. I think probably I need to do a breakout with Mr. McPherson. What floor is he on?
All right. Jail court iPhone. I'm sorry, Deputy, what's your name there, please?
Deputy Goldie.
Yes, Deputy Golfi. Do we have any other cases besides Mr. McPherson at your location?
I do not. He's the last one.
Okay. You're going to go into a breakout with Mr. McLean. Mr. McLean, is Mr. Bray's laptop?
We can do it on the main, Your Honor, because
Okay.
it's in courtroom, but public defenders and public defender social workers.
Okay, then Mr. McLean, you'll see a message on your screen to join the breakout room. And Ms. Strong, you can put the PD's domain, otherwise known as courtroom 2, into a breakout session along with jail court iPhone. And we are still waiting for ACDC to join the Zoom. All right, Mr. Jordan or Ms. Strong, can you reach out to ACDC and get an ETA?
I'll check when I see it.
Thank you. All right, Mr. McLean, don't forget to monitor the screen for the joint breakout room.
I just sent it, so I'm good.
Okay, thank you. We'll be in recess until we address this case or ACDC. Thank you. We can pause the whatever you want to pause right now. Thank you. All right, Mr. McLean, what's the announcement?
Your Honor, he would like to plead not guilty to both cases at this time. I can waive his presence and waive the arraignment entirely. I've got a form for that, and I'll be glad to do that.
All right, Mr. McLean will file a waiver of arraignment in case of DeMarcus McPherson, cases 23 CR 7709E and 23 CR 7432E. Both cases will be further notice for trial, and that concludes these matters. Thank you.
Thank you.
And Your Honor, the state would be revoking that offer, which would have been essentially a time-served offer with conditions of stay away and 40 hours community service FEIP.
All right, understood. Thank you. I think that concludes the cases at the jail court iPhone. Thank you very much, officer. And then I am inquiring as to the ETA of ACDC with any remaining cases.
I tried to call him, Judge, but I didn't get an answer. So I sent Deputy Milton an email, but she hasn't responded yet.
All right. Mr. McLean, which cases do you have from ACDC?
Ashley Johnson, Ashley, let's see, Vanessa, I believe it's Montgomery. Ashley and something else. There was a last name. I had two Ashleys over there.
Marcha?
I have
oh, sorry.
Ashley Marcha, position 22.
Correct. Ashley Marcha, M-A-R-C-H-A, an unusual name.
Okay.
Ashley Johnson, Vanessa Montgomery, and Don Shay Williams, D-O-N-S-H-A-E, Don Shay first name, Williams. Those four.
Okay. And Mr. Bray, who are your clients at ACDC?
Yes, Your Honor. I had position 11, Brianna Cole. That was a negotiated plea. Position 12 and 13, Nia Connor. I need just a brief breakout with her, but that would likely be a plea. And then position 14 and 15, Taisha Glover. That was going to be a bond hearing, not guilty plea.
All right, it is 11:30 right now. We're going to pause the recording and the live stream. We're going to give it about another 10 minutes. We have, it's been 2.5 hours since the calendar begun, and I've still not heard from ACDC. So courtroom 2, is Deputy Francois there by any chance?
No.
She stepped out, Your Honor.
All right. It's 11:32. I'll give it to 11:42. If Mr. McLean or Ms. Bray, if you can track down Deputy Francois to see what resources she can have to give us an update on ACDC.
Certainly.
All right. And Mr. Jordan, if there's a way we can contact ACDC directly to let them know that the court is waiting.
I just talked to someone at the Fulton County Jail. They had a power outage and they said the generator's been going up and down. So they're not receiving any phone calls at the moment or any emails.
Well,
he said it's been going on for like an hour and a half.
Okay. Well, it looks like it's a logistical issue. I don't know if we can address your clients today. I can reset them to December 19th. Oh, well, let's see, one by one. Okay, Mr. Bray, since you're in the courtroom,
Yes, Judge.
I don't know whether we're going to reach your client. So if they're having a infrastructure issue, Mr. McLean, it looks like it's a power shortage issue, and they're unable to take phone calls and unable to, unless of course, Deputy Francois can reach someone on a cell phone at the ACDC.
Right. I looked up and down the hallways that are near this courtroom, and they might be in courtroom number 1, which adjoins this in the back here. But unless that's the case, we can knock on that door, but usually the inmates are right next to the door, and it's usually kind of noisy, so that probably won't work, but we'll try it. right now, they must be transporting somebody onto another floor over at intake.
I don't know, sir. Let me see. Okay, tell you what, let's go over the calendar. I'm trying to use constructive use of dead time. So, and then hopefully we'll get something from, if anybody can contact anyone at ACDC on a cell phone, that would be very helpful and give us some real ideas of what's going on. Trying to. All right, Mr. Bray, on positions 1 and 2, position 1 was a plea, position 2 was null crossed.
That's correct, Your
Position 3 ballot was a plea. Position 4, Raduan Benjamin, which is position 4 and 5. What are we doing?
Your Honor, I will submit a waiver of arraignment. At this point, we're asking that he be reset to another SAP calendar, Your Honor. He had a number of criminal trespasses, and we needed to look further into the cases.
And what am I resetting it for? I'm just going to further notice it for trial.
Yes, Your Honor, for a potential plea, Your Honor. He had a plea that was close to letting him out. So I think if we can get things straightened out, and he's also got a bond on a felony case, I believe. So if he can resolve that felony case, post that bond, the plea would allow him to get out on these criminal trespass charges.
I am going to further notice both the cases to trial. Once your office gets an update on his status for the felony case, you can request the case be placed on a SAP calendar.
Yes, Judge.
All right, but I'm not going to sua sponte put it on a calendar and then nothing happens.
Yes, Your Honor.
All right, thank you. So these 2 cases are further notice for trial. Position 6 was a plea. Position 7, Mr. Bowie's case, the bench warrant was null crossed. All right, position 8 and 9, Mr. Cantu Davila is reset to December 19th at conflict counsel's request. Position 10, Jermaine Chappelle, is that an ACDC case?
Yeah, Mr. Chappelle is actually over in Cobb. He was produced this morning. We entered a not guilty plea, or we'd request to enter a not guilty plea, waive arraignment, and just have that set for trial.
All right. Position Chappelle is further notice for trial. Please make sure your waiver arraignments are submitted to Mr. Jordan this
Yes.
morning.
Strong.
Okay. Miss Strong, excuse me, Casey Strong. Okay, thank you. All right, position 11 is at ACDC, Brianna Cole. Position 12, Mia Connor is at ACDC. That's 12 and 13. Position 14, Taisha Glover is at 14 and 15 are at ACDC. So that brings us to position 16, Beyond Green. Mr. McLean, what we do with Beyond Green?
I informed him that the state had told us the DA had accepted their request.
And the state has submitted that order to Ms. Strong, Your Honor, with the DA's signature, the DA's office signature.
All right, I'm just going to take a moment. I'm talking to ACDC. 1 second, please.
And Ms. Falk, I have received all your orders.
Thank you, Ms. Strong.
Mr. Jordan, I'm going to put a couple of numbers in the chat to you. If you can call these numbers directly and see if we can get an update. These are cell numbers.
I'm not sure if he's in there, Judge, but you can call him out. I'll take him down.
Oh, I'm in here.
Oh, you're here? Okay. All right, sorry about that. All right, Mr. McLean, let's resume with, yes, Mr. Jordan, if you could call those two numbers and just give me an update, maybe we can get somewhere with ACDC. But in the meantime, we have, position 16 that is going to be transferred to the DA's office. Excuse me. 17, Hembrick was a plea. 18, Ashley Johnson, that is going to be pending ACDC. That's hopefully we'll get some information. And that was 18 and 19.
Right.
20, Lamar Map, 20 and 21. Mr. McLean?
Your Honor, I'll just file a written waiver of presence and arraignment.
All right. Position 20 and 21, a waiver of arraignment is going to be filed in both cases of further notice for trial. 22, Ashley Marcher is pending ACDC popping up.
All right, that's a plea.
Oh, that's going to be a plea? Okay.
Right.
I hope so. Position 23, DeMarcus McPherson is a waiver of arraignment and further notice for trial along with the other open case 23 CR 7432E. Position 24 is a plea. 25 is null crossed. Would that be correct? That was with Ricky Means.
That's correct.
All right. Position 26, Vanessa Montgomery is pending ACDC appearing.
Right, that's the social worker interview needed, Your Honor.
Oh, okay.
Communication problems and understanding of court procedures.
Do you want to reset it to 11 o'clock calendar on the 21st?
That would work, Your Honor. That would give me a chance to find out whether something similar about a week ago, a couple of people were on our main calendar when they were actually double booked for the competency calendar. And when I
Okay.
met her, I wondered if that was the case for her.
All right. We will position 26. Vanessa Montgomery is going to be reset to December 21st at 11 a.m. Position 27 was null crossed. 28, Tidwell was a plea. And position 19, Brandon Warner. That was on the position 29, Brandon Warner. These cases are further notice for trial. On the bench warrants, a $3,000 signature bond through the jail. On position 30, stalking is a $2,000 surety bond. And on position 31, loitering and prowling is a $1,000 surety bond. Position 32, John White was a plea. Position 33 and 34, Don Shea Williams. What's the announcement, Mr. McLean?
Social worker needed on those, Your Honor, very, very similar to this Montgomery situation.
And same outcome. Shall I reset it to the 21st Thursday calendar at 11 a.m.?
I think so, Your Honor, yes.
Johnson.
All right, on the bench warrant calendars, both matters were set aside. Well, position 1, the bench warrant, there is no bench warrant, so any bench warrants should have been, any pending bench warrants should be dismissed at present. And Mr. Bray is sending me a proposed order on that, correct?
Yes, Your Honor.
Okay, and position 2, setting aside the bench warrant. And Mr. McLean, did you want to do that? Or I think I offered to do that, right?
I never turned down an offer of free labor, but I'll be glad to do it. I've got a form for it.
Okay, I'm going to scratch out my thing and I'm going to rescind my free labor offer.
Sure, sure.
Okay.
It's legal work is fun, but it does take time.
Okay. And on the probation revocation calendar, positions 1 through 6 are reset to December 19th. Position 7, which is Jeremiah Durant, is probation. Well, the matter is reset to December 14th at 7 and 8. Position 9 is
I apologize, Judge. 7 and 8 are reset to when?
December 14th,
Oh, okay.
which is this Thursday. And then position 9 and 10, Finley, I believe the probation was revoked. He has 180 days left to serve in jail. Position 11, that is commuted to time served. 11 and 12. Position 13 is to continue. 13 and 14, they are to continue. Well, he is to continue on probation. That was Mr. Slanton. Correct?
Yes.
Okay. All right, which brings us back to our AC/DC cases.
Judge Law,
Yes, Mr. Jordan?
did you see my chat message?
Mm,
So they're not moving the inmates because of the power outage. So they would actually have to take the cell phone from floor to floor, which would
I
probably
see.
take a while.
All right. Mr. Jordan, how light is our December 14th calendar?
I don't think it's bad because we can reset them to Thursday. I think we
Okay.
had 20 cases on the regular calendar.
Okay.
And then the probation calendar has 6 cases.
Okay. So Mr. Bray and Mr. McLean, I do apologize, but AC/DC will not be able to join us on the SAP calendar this morning. So hopefully things will be up and running by Thursday at 9 a.m. For position 11, that would be Mr. Bray's cases, 12 and 13 and 14 and 15. Those are reset to December 14th at 9 a.m. Would that be correct, Mr. Bray?
Yes, Your Honor, that's my understanding.
Okay.
I apologize, Judge Law. Can you go, my Zoom went out. What were the resets for the ACDC?
December 14th, and that is for positions 11, 12 and 13, 14 and 15. For the Mr. McLean's cases, position 18, position 19 is reset to December 14. Position 22 is excuse me, was it position? No, position 22 is reset to December 14. And position 26 is reset to December 21st at 11 a.m.
Okay, so just to confirm, 11 through
11, 12, 13, 14, and 15 are reset to December 14th at 9 a.m.
Okay.
18, 19, and 22 are reset to December 14th at 9 a.m. 22 as well? Correction, yeah, that's correct. Position 26 is reset to December 21st, next Thursday at 11 a.m. And position 33 and 34 are reset to December 21st, next Thursday at 11 a.m. We good, Ms. Strong?
Yes, ma'am.
Okay. All right, Ms. Jordan, keep those numbers I gave you for ACDC. I think those may be good numbers. And otherwise, at the present time, that concludes our calendar and we will
Judge.
resume at 2 o'clock.
Judge Law, but what did we do with position number 5?
Position number 5. That is, Mr. Bray is going to submit a waiver of arraignment, and that's further notice for trial, along with position number 4. 4 and 5 are together.
Oh, I had, okay, thank you.
All right. Anything else from anyone?
No, ma'am, I'm good now.
All right, we're in recess until the 2 o'clock C calendar. Thank you. Thank you, Francois. Appreciate it.
You're welcome, Judge. Thank you.
Deputy Francois. Deputy Francois. Did you get my message about Attorney Watson Cafe?